that a person be a viable candidate for the president of the United States, and I don't get this. The jury verdict is resounding, $83.3 million. The past $5 million, I discovered he paid it into the court. How is that possible?
Attorney Lee, and good morning, everyone. Thanks for having me, Attorney Lee. It's outrageous, absolutely outrageous that an individual can continue to run for president with 91 indictments, cases pending in 4 courts across this country. It's interesting with the New York case involving fraud with respect to his net worth, and the judge has already issued a partial summary judgment in that case that he submitted fraudulent valuations of his assets in order to obtain loans. And in that case, as you know, prosecutor Letitia James, after 11 weeks of trial, is advocating a civil judgment against the former president in the amount of $370 million. And on top of that, 9% interest. So 370 million potential liability plus this 83 million that has been awarded just this week in the Carroll case. And as you know, he must post a bond until those appeals are exhausted. Are we beginning to chip away at his fortune at this point with those kinds of numbers?
Well, I don't know. Well, Milton, here's my concern. We got R. Kelly, is he in prison now for raping some person that a long time ago? How does the former president, now the jury, determine? I don't understand the difference. A civil jury say he raped a woman in a department store.
Mm-hmm. Well, I guess the statute of limitation, the criminal statute of limitation, is not the same as this civil statute of limitation. So we have a difference in the time period that a suit can be filed and a criminal action can be filed against an individual. But, you know, power goes to, I had a friend of mine, a former judge, deceased judge, he and I talked once. He said, you know, power is an aphrodisiac. Sitting up here on this bench, more people come before me with Google eyes and praise down, and you know, it's just part of our society. Look at what has happened down in Georgia with people involved with the prosecution of our former president. People begin to think they can do what they see fit for them when they get to a certain level of power. I won't say everybody does that, but many of us get intoxicated with them. So when you asked about Mr. Trump, there's nothing, you know, he said it when he ran for president the first time, what he can do to women. You know, he could grab them by the vagina area and do what he want. He laughed about it. We knew that. He was elected president.
And yet his base would, when polled, stated that even with right. Convictions, they would still vote for him. So that really tells you something about our society.
They separated the criteria. They said that wasn't, you know, that incident was not a criteria for being president of the United States. They looked at his achievement in business and his accomplishments according to him, and according to him, his worth. So he's
also blaming the conviction on the Biden administration.
All right.
You know, and of course, he's claiming that these are political witch hunts against him. And remember, he said that he could stand in the middle of a New York street and shoot someone. and still would not be held accountable.
Right, right.
That's terrible. We'll go to the line.
So
Let's
he's
talk
pushing-
to a caller real quickly. Hey, caller, you have a question or comment for us today?
All right, I'm good, brother Nate. How you doing? Can you hear me?
Hey, by the way, let me announce that callers that listen to us, I forgot to announce this at the beginning. You can reach us on our direct line at 833-653-3529, 833-653-3529. Also, we're on YouTube, we're on Facebook, we're on LinkedIn, and also on 92.7 FM and some others, about 7 other stations. So you could Google us and determine the platform. In any event, go ahead, sir.
How you doing? Brother Motep here, and Attorney Banks, Attorney Grimes. Thank you for taking my call. I'll be very brief here. If you look at X, formerly known as Twitter, which I try to gauge at, do keep up with Roland Martin, Ron Filipowski, an attorney who was a federal attorney for a while, Cheryl Eiffel over the NAACP Legal Defense Fund, a number of other people, Philip Lewis, attorney, a reporter for out of New York, I'm out of D.C., and a few others, Attorney Kasim Rashid, I think he's running for office in Illinois. I think you're familiar with him, Attorney Banks. And so Donald Trump is the epitome of DEI. The backlash and everything from DEI that you read on there is horrendous. It is completely horrendous. And some white people, I'll be clear to make some, because there are people who are trying to advocate on the other side. But there's a large percent who don't look at the benefit that they've gotten because they created the system, they legalized the system, they passed the laws in the system, and then they completely make up things as they go to try to change it when they don't like it, i.e. the governor of Texas, i.e. Trump, after he walked out the other day lambasting Judge Kaplan and hollering about the criminal justice system is not right. See, it's a double standard. He benefits from a complete and present double standard. And this has to be communicated. My mother, who I talked to, wise 83-year-old, one that's probably the smartest person I know living now, told me if she was the Democrats, when the campaign heats up, every commercial, I would call him a rapist in it. We know that. You just said the judge said that's what he was. So this is not happenstance. It's not mislabeling. It is what the judge said he did. And she said in every commercial, she would make sure to call him a rapist, because that's what he is. Lastly, I want to throw in there, I read the article about the young lady in Ohio who had the miscarriage in the bathroom. That's a horrendous story, Attorney Banks. You may be more familiar with that, I'm sure. It's on NBC Black People. You need to go look it up. It's a horrendous story. She was mistreated by the hospital 3 times. The nurse committed malfeasance by calling the police on her. I hope she gets a good attorney, sue the hospital system and everything else. It just shows you these draconian laws. Again, the late Thurgood Marshall said the conditions of Black people today, even when he said it back in the 70s, were direct related to the laws that were passed. And we get hit upside the head with these draconian laws because they try to enforce them. Now thankfully, the grand jury decided not to charge or anything, but it shouldn't even went to that point. It should have gotten to that point. And that's only because Ohio is battling in this since the Dodd decision. So we've got a lot of fish to fry here. We can't be worrying about, I love Cat Williams and that, and I'm happy for that, but we got real fish to fry. But if I'm the Democrats, as my mother said, I make sure I call him the rapist he is in every ad. Do not let him benefit from the double standard of white privilege that's what he has been benefiting from. And thank you for taking my call.
Wow, that's a lot to digest, Attorney Bank, Attorney Grime. The only thing I could say about that is that he mentioned his double standard. I remember the great Bill Cosby was tried and convicted of rape of a lady that occurred, what, back in the 70s? Or was it the 70s or so? And, this was in the 90s, that the rape was adjudicated to on Jean Carroll. And, I know that there are statute of limitation issues, but they carved out an exception to allow lawsuits. I wonder why the legislators in that state, because they convicted R. Kelly, Attorney Grimes, and that was something that had happened, 12 years earlier? And I thought that most of these statutes, like in civil cases, they're 2 to 4 years top usually. And criminal statutes, I surmise was longer. That's outside my practice area, but I'm still miffed as to R. Kelly is convicted in New York. And now they determined that the former president also did rape. I don't get it.
That's the state of the law. That's the state of the law. It can be interpreted it's flexible. It's movable. That's what it's written. That's how it's written.
All of these analogies can be made and just demonstrate the double standard that the caller was referencing. And I'm well aware of the case of Brittany Watts in Ohio, and she discovered that she was miscarrying her 22-week baby, and the baby had been declared non-viable by doctors a few days later. Had been declared non-viable by doctors, and however, she spent 19 hours in the hospital over 2 days. She was begging to be induced, but because of the law and the hospital's concern about the abortion laws, they sent her home. And so she ultimately miscarried at home, returned to the hospital where the police were called, and she's charged with abusing a corpse after she delivered, her baby in the bathroom, and the remains of the fetus was found lodged in the toilet. I mean, this is just a devastating story. And we hear about this one, but there's so many other women that are suffering and potentially dying because they can't get the health care that they so desperately need.
Yeah. By the way, Attorney Grimes, that's a good point, Attorney Banks. I just looked up the R. Kelly case. Those rapes happened back in 1990, 1991. Of the young women with R. Kelly, in which he got 30 years in prison for.
Well, supposedly the law has recognized that a lot of women, especially, don't, I guess men too are raped, if you follow me, but the embarrassment of it, the humiliation of it, the people not believing, all of that goes into people not reporting their rapes at the time or in proximity to the time that they occur. So minds have recognized that there's a delayed reporting of those before people can get comfortable with reporting those acts perpetrated against them. It may be stretched too far, Nathaniel, but that is the law.
I was very surprised in the year 2022 or so, or 3, that the law was even changed to reopen the statute of limitations. As you know, when we're in law school, there's a statute of limitations, right? For many crimes and offenses. And I never would have thought at that time, as we were evolving as attorneys, that there would be a law passed that would reopen a statute of limitations for any reason. What do you think? Was
I,
that
I,
a surprise to you that that would be the case? Because when you're talking about going back 30 years, I mean, the evidence is gone, potentially, the witnesses are no longer available. It's really difficult.
yeah, but some people live with this pain. I know psychologically, they bury it, but it affects them all of their life. And so I don't know, Vanita, what's right and what's wrong in extending the statute of limitation. But I guess I'm on both sides of the fence. Some of these cases I agree with, like Boy Scouts, over 85,000 um, Boy Scouts were raped and molested during a particular time in history. Here, recent history, they find out, uh, aided by the Mormon Church and hiding it. We got a complex society, and laws are made to protect us. To cast them in stone may not be the best thing. So if it's rational to open them up, and it's a strong enough argument, even though I'm a criminal defense lawyer, um, I can see the benefit of it to our society. When you look at some
Well,
of these priests, when you look at some of these priests and Boy Scout leaders who have molested, oh man, thousands of young people, and those young people were scared into reporting it at the time. Should it be opened up 20 years, 30 years later when these people are grown enough to deal with the pain of revealing it? I don't know.
well, fascinating. Attorney Banks, the next story has to do with the execution this week down in Alabama. Uh, you recall that case where and I can't remember what gas they used to
Nitrogen.
nitrogen. Okay. I thought that was kind of bizarre way to kill somebody.
Liquid nitrogen gas. This is a fascinating case.
Well, nitrogen and oxygen, I think, is mixed in our air anyway, but if you just give a person nitrogen and take out the oxygen, I think that suffocates them or kills them.
This is a fascinating case dating back to 1988 when the inmate Kenneth Smith was charged with a murder for hire of a woman, and he was sentenced to death in 1989, but in 1992 his conviction was overturned on appeal on grounds that Black jurors were excluded from the jury. And so he was retried in 1996 and convicted. A jury voted 11-1 on a life sentence for Mr. Smith, which the judge in the case overruled the jury and sentenced him to death. And in November 2022, there were 2 botched execution attempts by lethal injection. And so just last week, a couple days ago, after the U.S. Supreme Court denied a stay of execution, he was executed by liquid nitrous gas.
Wow.
Many are advocating that he was subjected to a violation of his constitutional rights against cruel and unusual punishment. What do you think?
That Milton area, is that
Well, I'm against. Let me put out there and get it clear. I'm against the death penalty. I think the death penalty is about as barbaric of a law as we have, including the rape law and everything else. It doesn't bring anybody back, and it doesn't deter crime. They've studied it long enough to know that when someone is committing a killing or a robbery or something, they're not thinking about the death penalty. They could have read it the day before, but people just don't work like that. So it's not a deterrent, and it's a draconian penalty for criminal conduct in the first place. But I think a lot of people are saying this is cruel and unusual punishment. Well, it was cruel and unusual punishment before, to me, before it failed in several attempts to kill this man. But if the law has said that he must die, and they chose this method, if a person was hung and the rope broke, we were at dinner last night, former Ninth Circuit judge and his father and family, and this discussion came up. And I thought of the analogy of if it was a hanging and the rope broke, would they say, well, get back on the horse and ride away because the rope broke? Or would they get another rope to complete this sentence that society imposed on this human being? So I don't know that it's cruel and unusual punishment because it's multiple attempts to put him to death, or is it cruel and unusual punishment because of the technique and the way it was done? I don't know if he was in pain or not. Or is it cruel and unusual punishment because he's just getting the death sentence? People don't seem to be so objectable to a death sentence. But it was the way this one was carried out. Have scientists approved of this method, that the person is unconscious when they're suffocated with this medication or with this drug? So I think a lot of people are upset because it was several attempts to take his life. But I don't think that's the issue.
I saw the minister who described it as a horrifying scene, about vomiting, movement, that it was a form of torture because it took so long for him to die. And, it was just, but what I didn't understand about it is that I think the other co-defendant, as I recall the story, Attorney Banks, they had been executed back in 2010, and much earlier. So I think it was just 2, maybe 3 people that died. Now, I know in Alabama, what's unusual, they have 165 inmates currently on death row. And I was looking at the number. The odd thing about it, the inmates, I guess 43 of the 165 said they want to die by the nitrogen hypoxia over the lethal injection. I thought that was kind of bizarre. And I've never watched a death penalty being performed. It's outside my practice area. That's not an area of law that I ever want to do. But it just seemed odd to me that, I guess they give them their last wish. You could die by nitrogen hypoxia or lethal injection. I mean, I don't get it. I mean, what, in the lethal injection, would they stick something in your vein and?
Well, they call it a cocktail, if I remember, Nathan. I haven't looked at this in a while. It's a mixture of different drugs. One drug, puts you to sleep, supposedly, and I won't say make you pain-free, but you're sort of unconscious when they put the drug in you, like I forgot the name of the drug now, that they don't have as many drug companies making it. It's a shortage of the drug needed to actually cause the death, cause the lung and the organs to collapse and stop functioning and cause the body to die. Supposedly, you're not conscious of that. But again, I go back to the premise, the death penalty is barbaric, and they haven't been able to make it appropriate way of doing it, or find the right way to do it. I mean, back in the old days, they used to hang you. In the military or other situations, they would shoot you. But causing someone death, I don't think you're going to ever find a pleasant way to do that.
And most importantly for me is the fact that we know that there's a demonstrated disproportional impact on the administration of the death penalty on African-American men and people of color. And Brian Stevenson, through his Equal Justice Initiative, has won the reversal or release from prison for over 140 wrongfully condemned prisoners on death row. And so if there is the possibility that one innocent person would be killed via the death penalty, I think that's justification for it not to be administered. And of course, here in Illinois, the death penalty was overruled many years ago.
Vanita, I've been to sessions and read quite a bit of material when I was doing death penalty cases to listen to the explanation by prosecutors as to why the death penalty is justified, and that the death of an innocent person, one innocent person, is worth protecting society from the criminal element they rationalize, and that should be accepted. That the innocent is going to have to die in order to protect society as a whole, and that's how they explain it. I don't know how a person can do that either, or accept that either, but that is the rationale that's given, part of the rationale that's given.
Well, here's a problem I have with this whole scenario. In Alabama, they have a flawed system. Their system is right with racial bias. They have a whole litany of African American who falsely convicted and sentenced to death. I mean, it's a whole, and some of the cases are just sinister. It seemed like that the people who did this should be in prison now. Like, for example, I would look at the case of Walter McMillan, black male. He was convicted and sentenced to death for murder of a young white woman who worked as a clerk in a dry cleaning store in Monroeville, Alabama. They put him on death row before the trial. The trial lasted 2 days. They fabricated witness testimony. They fabricated evidence. He was sentenced to death. They then got reversed because they found evidence that exonerated him. And of course, he was released. But the people that put that trial together, I didn't see where any of those people were held accountable. And then one of the problems with Alabama is that up until recently, I saw that they paid to represent these people on death row initially, Milton, $1,500. They increased it to $7,500. I mean, so they're saying work for a person whose life is at stake, and we're going to pay you about $5 an hour. I mean, it's ludicrous. So this system that they're using and it disproportionately affect minorities. And the big problem is that they don't have adequate representation at trial. And because these cases are very expensive to do, you know that. I mean, your scientific evidence, you have to have experts on, you have DNA, and you have all these lab type testing. And so those experts are very expensive. We hire experts in all my civil trials, and it's hard to do any civil trials now when you pay out less than $40,000 to $50,000 in expert fees. And so now on the criminal side, how does an average family afford to pay for a defense?
The average family cannot afford to pay an attorney and for the course of experts that's required in many of these cases, the way the wealthy can. And it's not just Alabama, man. I worked on a case in Texas where a young man, he was a Caucasian, accused of a rape and was wrongfully convicted. And he ended up, because he was put on death row, he had a mistrial, one trial, had two trials, and was on his way to a fourth trial and was scared into pleading guilty. The expert had lied. The expert for the prosecution had lied. A fingerprint expert said that his fingerprint was found inside of the window in the young woman's house, and that means that he had been there within 24 hours before she died, because a fingerprint only lived in the air for 24 hours. A jailhouse snitch had said that he confessed to him. When the second trial came around, the defense had obtained some additional discovery where the fingerprint expert had sent off a letter to join the Society of Fingerprint Experts, and it said that he had made a mistake in testifying only one time, and that was in testifying that fingerprint only lasts 24 hours, when in truth, a fingerprint lasts, they find them in caves, and that's 1,000 years old. They can, fingerprints, because of the content of the oil in our body, can last centuries. And the expert said he made a mistake. But the judge would not let the defense use that recantation of this expert because prosecution had mistakenly given the document, this letter, to the defense. And the letter was confidential. It was private. And so they could not cross-examine him on his mistake. So he testified in the next trial that a fingerprint only lasts 24 hours. The court knew he was lying. Prosecutor knew he was lying, but he testified, and the young man was convicted again. He went on to death row, and up on death row because he was small in stature, and he didn't survive very well on death row. He was raped in the prison yard where the death row inmates, 3 or 4 of them are allowed out at a time. He was raped on that yard by a man twice his size, and carved up and put a name Sydney on his right cheek, and said, "You're gonna be my woman in this as long as we here together." And he made him that. He made him that. He made him provide sexual favors to other inmates for a price. He used him, sold him like that. And one day this guy got so frustrated because someone put a kite in his cell, a message that you ought to just get rid of that flap covering your private part because you don't need it for anything. And sure enough, he took a razor blade and cut off his penis and threw it outside of his cell. And they discovered it because he was bleeding out. Guard saw the blood coming from under his cell. And so that was his dealing with it. But he didn't want to become violent in prison because he said it would take away his chances of appeal. So when the case came up the 4th time for trial, after he had amputated his private part, they discovered that the woman's panties were still inside of her jeans that she had on during the rape. And they wanted to test the DNA. They saw a semen spot in the panties that she wore. Now, he had 2 actual trials and a mistrial. And then they had not discovered these panties, hadn't examined the evidence that well.
Oh, it's terrible.
And so his name is Kerry Max Cook. He wrote a book about this. Anyway, and the judge wouldn't let them have the time to get the DNA testing. He said, this case is going to trial. But they just discovered this a couple of weeks earlier. And this young man pled guilty to voluntary murder. A week or so many weeks after that, the DNA came back, and it was not his DNA. It was her former boyfriend, who was a married tennis player, who he said they had stopped seeing each other months earlier. And he was the culprit in her death. They didn't prosecute him. This guy, Kerry Max Cook, was released after pleading guilty to voluntary. I think he pled guilty to voluntary murder. So experts are not all that they're put up to be sometimes. And but yes, getting back on point, private sector generally cannot afford a lawyer for a death penalty case because of all the stuff that you should do to save this person's life.
That's an incredible story.
The book is Kerry Max Cook. But this injustice prevails throughout our society, Nathaniel. And Alabama doesn't have the premium on it.
That's a terrible story about how there's a flaw in our system, And I saw that story when you were giving it. That's such an incredible. Locally, our local prosecutor took the initiative to have the staff review cases to ascertain whether or not persons that have been convicted have evidence of innocence. So they had an ongoing project to try to see whether or not there have been mistakes made in our criminal justice system. And I think that's an important factor because mistakes are made all the time. I remember when I was a young lawyer and a client of mine who was arrested and charged with rape. And to make a long story short, the alleged victim, this is back in, I think, 1982, 83, she gave me a recorded statement and basically said that she never met this guy. And my guy was like, I don't know, he was over 6 feet tall, way over 240 pounds. And the guy who committed the offense was 5'9", about 145 pounds. So there's 100 pounds different in weight and about 6 inches different in height between the two persons. So she gave me this statement. Luckily, I had my recorder, Milton, at the time, and I recorded it. And so I then had the charges dropped, right? Based on the fact that I scheduled a deposition in the prosecutor's office. The prosecutor apparently talked to her, and then they dropped the charges, right? So I then proceeded to file a civil lawsuit because the police officer who filed the charges, caused to be filed, he included false evidence. Okay. And so when I proceeded with the civil lawsuit, much to my chagrin, this young lady didn't get in trouble with law enforcement. She got in trouble. And once she got in trouble, we scheduled her deposition. In the civil case, they did. And in the civil case, she flipped. In the civil case, she said under oath that my client did rape her. And then it got worse. And she said that I had agreed to pay her money to give false testimony, right? Luckily, I was a smart lawyer then. I then played the tape step by step. And in the deposition, I proved that she committed perjury. And then I found out that she did that because she had a drug charge that the cop agreed to drop if he cooperated. So I got in more wrongdoing. And so early on, you ran into situations like that, but it takes the foresight as a lawyer to anticipate that there's going to be some corruption in the process.
Yeah, I'm on a board of directors of Miracle of Innocence. It's a program that deals with wrongfully convicted individuals. I've been on this board for about 3 years. The young man who found this organization, Daryl Burton, I've known Daryl now, he did 24 years in the Missouri State Prison, one of the most notorious prisons. Is equal to the one in Louisiana. Damn, I can't remember the name now, but you know, they have people working on chain gangs. They have brutal conditions. But Daryl did 24 years for murder at a robbery at a gas station. And he said his public defender spent an hour with him before trial. An hour, 1 hour. And they went to trial and he was found guilty. But he kept fighting. He kept fighting for his innocence and got the attention of a lawyer there in Missouri. But eventually, he got someone to look at the evidence, and they found in there a report that had not been given to his defense lawyer. And that report was of a witness who was at this gas station. And she looked at a photo lineup of individuals, of 6 individuals, And she said, he looks like the person, but this looks more like the person. And they went and talked to this individual. She said, yeah, well, this young man is too dark to be the individual. The young man who was black, who was a Negro at the time, they called us, he was brown to light skin. Like you can see the difference in your complexion and mine. I'm darker than you, you're browner. Vanita doesn't show herself on camera, so I don't know what color she is. That she could be half white, I don't know. But in any event, it was a complexion thing. And she said, he's too dark. Person I saw was light to bright, whichever goes. But so I tease him to this day. I said, you were too black to do the murder. And that should be the name of your book. So he has written a book, Daryl Burton, and he says a little bit about that. But it was because of his dark skin that he was eventually set free. And the fact that the prosecution did not release the statement of this witness to his defense lawyer. This brother was in prison for 24 years, Nathaniel. Yeah. And we have people, I don't know, every week there's probably 3 to 5 people declaring their innocence for one reason or another. And we don't require DNA to exonerate necessarily, as opposed to some of it is just factual information that didn't come forward at the time of their charge or conviction.
And I would argue, use the arguments or the points that you just raised, Milton, to rebut the argument that a life taken through the death penalty unjustly compensates for the imposition of the death penalty in a righteous situation. Did that make sense? That the number of people that could be subject to the death penalty unjustly outweighs its imposition at all.
Well, it may make sense to you, but undoubtedly the ones that charge or prosecute for the death penalty doesn't accept that.
I agree. I agree.
Attorney Banks, you raised another issue before the show. Very briefly, we have another African-American female prosecutor under attack again, Fannie Willis, who filed charges against Trump. It seemed like this is a pattern. You know, we had Maryland, we had Missouri, Florida. These African-American female prosecutors, it seemed like they have a target on their back, it seems like. I mean, what's up with this Fannie Willis?
Well, I think that time will tell in this particular case, and you're absolutely right. We're seeing African-American female prosecutors being targeted across the country, from Letitia James to Marilyn Mosby to Kim Fox here in Illinois to Fannie Willis. But what's interesting about this latest development is that she purportedly added to the prosecution team someone that she has a personal relationship with. And also talking about the case in other venues, like one of the churches, I believe it was a church in Georgia, correct me if I'm wrong, but one of the churches, I think probably on or about Martin Luther King's birthday, that she was a keynote speaker. And so the question in this case, and the Trump team has filed a motion to remove her from the case because of the purported, alleged, asserted relationship with this other member of the prosecution team. I understand. And of course, from everything I'm reading, there may not be an outright conflict of interest, but there's a question of whether or not there's an appearance of a conflict.
Well, here's my problem, Attorney Banks. A husband and wife could have cases against them and be in competing law firms. There's been ethics opinion. I don't see the connection between trying to remove her from the case versus a marital infidelity or romantic relationship. In other words, if their allegation is that he billed the taxpayer the $600,000 improperly for work he didn't do, that's one aspect between him, ethics, and overcharging the county, right? But how does that translate into the fact that that have anything to do with prosecution of Donald Trump? And what, 5 of the people already pled guilty. So I'm trying to figure out I don't get the connection in terms of why would that be relevant to whether or not you're going to prosecute these people when they went before a grand jury?
It was poor timing for their love affair at this particular time, because it's something that can be used as fodder for the defense. You go to Cancun on a romantic venture for a week during your divorce. You know your other spouse, if they know that, is going to try to make something of it, whether or not she informed of that. I don't know where it came from. But that wasn't a very intelligent thing to do, because that's just how life is, Nathaniel. And you and I both know that, and so does Vanita. People will take whatever little negative they can and throw it up on the wall. If it sticks, it sticks. So they go to Cancun on this romantic venture for a week or something, and he gets $650,000 within a 2-year period of time for his billing on the case, which that's $325,000 a year average. It's hard to bill at $250 an hour for that much money unless you're working that case only full time. It just throws thesis matter on the wall for the Trump team to gather to attack you. And
they're master at attacking in this way, right? The Trump
yes,
team
they are.
master at it.
Yeah.
And,
So you got to have enough intelligence to defend yourself in the event that this comes about, or just don't give them that ammunition. So I love the fact that we have an African-American female prosecutor on this case, but I do believe there was a judgment mistake.
The optics are just bad, right? And it might not be a classic textbook conflict of interest, but the appearance here just
right.
The timing,
some impropriety.
The appearance of impropriety. I mean, you really just, she had a clean case, right?
Right. Right, Vanita.
I mean, the case was clean. And this just muddies the water and again gives them something to throw up against the wall. When you don't have the facts, right? You just, was just, fodder for them to just throw up against the wall. And so it just wasn't needed at this time. So I just, as I shared this with you, colleagues, what was she thinking?
Right.
Well, at this point, I'm going to give them both the benefit of the doubt.
Okay, that's good.
I'll wait until all the evidence come out and see what happens. Because there's a collateral track here. Lawyers are governed by significant ethical rules. If he did fraudulent billing, that's a separate matter to the county.
Yes.
So work he did when you have to turn in timesheets. And I looked at that and looked like the other prosecutors also billed over $600,000. So, I mean, it's a labor-intensive case. I mean, a case of that magnitude, I could see in 2 years, that's about 700 billable hours a year. I don't know, if you're working on a case like that, that's half your time. And I don't think that's a lot of money for 2 years of work in the legal profession. I just don't think so. You know, I have my close friend down there in Georgia. He billed 2,500 hours in 1 year. Billable time, I mean, which meant that he worked 7 days a week. So,
Yeah. How many hours a day?
well, he worked, from 8 in the morning to 8 at night, about 12 hours a typical day.
Mhm.
But
Okay.
see, we don't know what this lawyer's work hours were and things like that. So I like to wait and see before I pass judgment to see exactly what occurred. What about that?
Agreed.
I hear you. I'm gonna give him the
Wholeheartedly.
benefit of the doubt. I don't think it's direct conflict either, but it's a bad appearance. And I bill too on cases. I put together billings, and you know, we're all human.
Also, for the benefit of records, I see lawyers bill now between about $250 to about $3,500 an hour now. By the way, in my last products
Yeah.
liability case, the opposing counsel billable rate was $2,500 per hour. And so on the one case, Milton, his bill was $2.1 million.
Well,
Two
he
point
was
one million on a single freaking case up
Yeah.
until the final pretrial conference, 2.1 million. And so when I look at that, I just start laughing. I say, in 2 years he built 600,000. Hell, I got a lawyer build 2.1 million in 2 years. So
Right, right, right,
know,
right.
some lawyers are worth more than others. Some guys bill at 175 an hour, others bill at 2,500 an hour.
yeah.
The
But
range
anyway,
varies.
well, I'd like to thank everybody for joining us today, and I'd like to thank my superstar panels. And don't forget, join us next week as we deal with important legal issue of today. Thank you, everyone, and go out and have a great time today. And Lord, continue to bless each and every one of you.
Thank
Wow.
you.
Bye,
Have a
everyone.
great day and weekend.
You too.